a second motion for partial summary judgment filed on May 1st, 2026. And those were both filed by defendants, and plaintiff's motion to quash or modify subpoena filed on April 7th, 2026. The court set this matter for 30 minutes. The court can provide a little extra time, 35 minutes for substantive argument here. The court's proposal would be 15 minutes on the, that's about 7.5 minutes each on the March 2nd motion for partial summary judgment, 10 minutes, about 5 minutes each on the May 1st motion for partial summary judgment, and 10 minutes or 5 minutes each on the subpoena dispute. As defendants are the moving party on the motions for summary judgment, I would have the defendants go first, and you could reserve time for rebuttal. Is there anything for the court to take up before we begin this morning from either Mr. Rose or Mr. Hecht? Mr. Rose, we'll start with you.
Oh, sorry.
I'm good, thanks.
Mr. Rose? Mr. Rose,
I'm good. Sorry
I'm hearing a lot of background news. Are you able to, Mr. Rose, can you hear me? Mr. Rose? Mr. Rose, are you able to hear me? I think you might be muted. Mr. Rose, did we lose you?
No, sorry, I'm here. I was telling the gardeners to stop blowing their blower right outside my window.
Thank you. I appreciate that, because we were getting a lot of noise in the courtroom through the audio. So thank you for that. Anything to take up before we begin today?
I'm good, thank you.
All right, Mr. Hecht, anything on your end?
Nothing from my end, Your Honor.
Very well. Then Mr. Hecht, as the counsel for the moving party on the two motions for partial summary judgment, you may begin first addressing the March 2nd motion for partial summary judgment. And you have about 7.5 minutes.
Sure, Your Honor. So as you stated, there's a lot to cover here. So a lot of what I'll be doing is addressing the high level overview points and reserving some of my time for any questions you have or any rebuttal necessary. To start with the first motion, I want to talk about a little bit about the wrongful termination claim that we're moving on. This is pure black letter law. You can do an analysis. I think the analysis starts and ends at the first prong for the statute, that there's no agreement signed by both parties. And at worst, you need the party to be charged to sign the agreement, which is not present here. You could stop the analysis there. If you wanted to go to the second prong, that even if there was a signed agreement, which there isn't, there's no protected activity here. The statute states that he must allege some sort of violation of either the statute or the Arizona Constitution, and that's not present here. Again, I think you can end the analysis after the first prong, but even if you wanted to go to the second prong, it fails as well. I'll move on to the alter ego now. Early in this case, I believe before it was a different judge, Your Honor, but there was a lot of alter ego defendants that were initially dismissed from this case, and the previous judge left Dan Noma personally because it was a little bit too early to dismiss it on the motion to dismiss, and kept it in. However, this is 3 years later now, and Mr. Rose has done absolutely nothing to meet the burden of piercing the corporate veil for Dan Noma. He must show unity of control, as well as respecting the corporate form would sanction fraud or promote injustice. This record is completely void of any commingling or anything that would make Dan Noma personally liable for the allegations in this complaint. Again, it's been 3 years, and that he has shown nothing to prove the alter ego. So we would move to dismiss that as well. The third kind of issue I'll attack is the stock/equity. As a preliminary note, Mr. Rose doesn't have standing to make this claim. The Luther Pounding Trust is the party, and although he can tell us, he signed for Luther Pounding Trust, he has produced absolutely no documents proving that he's an authorized trustee or anything on the record that is proving he's actually allowed to sign for Luther Pounding Trust. So that's kind of a preliminary issue there. Second, the parties, Mr. Rose and myself, disagree on which statute applies here, but under either statute, it fails. Under our statute, which is, we believe is ARS 10620, a stock subscription is unenforceable unless it's signed by the party to be charged. Again, no, Dan Noma, Get Your Nest, no one from Get Your Nest ever signed this contract or the stock subscription. But even if we take Rose's theory as correct, which is the services for share, I believe it's 10621. One, again, no enforceable signed agreement by the parties. There's a district court case, Clark v. Ayurveda Corp. Although it's district court, it does say that this stock agreement was only valid because all the stockholders signed the agreement. But even if you don't want to go that route, the statute itself has an exception in 10621B at the end that says, except future services cannot constitute valid consideration for this. So even if you want to go the statute route and read it, there's an express condition that says future consideration does not count here. And then I'll move to the breach of contract claim. Again, I've mentioned it a couple of times here. There's never an executed contract. The only party ever signed it was Jonathan Rose, Mr. Rose. And the statute ARS 23-1501A2 must be signed by both parties. And if you want to get past that hurdle, which we don't think you can, but even if you wanted to say that there was somehow a contract in an alternate universe that was signed by both parties, partial performance is also not considered, is not sufficient to create one. So there's that exception as well. This is the lack of formation here is a legal question because it turns on these undisputed, unsigned documents. You know, at best, Mr. Rose has a unjust enrichment claim here. The fraudulent inducement claim, it doesn't reach the Rule 9 particularity standard, the who, what, when, and even if it gets past the pleading standard, we're well past, pleading, and we're 3 years into this litigation, and he hasn't produced that information that would reach that standard as well. That's all I'll have on the first MSJ, and then unless you have any questions, Your Honor, I don't know how you want to, if you want me to just move into my second.
No, that's I appreciate your time, counsel, and I'll allow you to use the excess of your time in the rest of your time in rebuttal. Mr. Rose, thank you for your patience. I did have a chance to read the briefing. I did want to make sure I understood both parties' positions on all issues to the extent that you wish to talk to the court about them, but particularly on the alter ego issue, along with the arguments raised in the briefs and at oral argument on the formation and on the stock and equity issues. So, Mr. Rose, I wanted to give you an opportunity to respond to those.
Fabulous, thank you, Your Honor. So the first part,
Mr. Rose, if you could tell we're getting a lot of noise, or we were getting a lot of noise. It looks like the noise died down. Go ahead.
Oh, sorry. Yeah, hi. So on contract formation is all about conduct. When, you know...
And sorry, I don't mean to cut you off. This won't go against your time, but is it possible to have the work that's being done outside the House stop for the purposes of this hearing?
I have yelled at them, so they should be done.
Okay, thanks. Go ahead.
Okay. So on the contract formation, conduct is a part of contract formation. If I applied to a job to become a lawyer or a partner at Denton's and went through that process, then someone would issue me, I would do a job interview. I would not say I've been hired. They would then have counsel prepare and draft a contract. I would still not say I've been hired. They would then say, hey, we're giving you the job. Here's the job. Sign this. We're good to go. I would assume I have been hired. Then when they grant you an email address and you have an email address, no one gives you an email address if you haven't been hired. No one would send a letter from the COO saying, welcome to the team. And no one would send emails to their third-party outside customers saying, let me introduce my CIO to you and let him conduct negotiations on behalf of the company. So you have a series of actions that clearly show the intent to form a contract was in place. They say the negotiations never ripen, and their own documents literally say otherwise. So March 30th, 2023, their outside counsel at Fenimore, which is a firm that drafted the legal agreements, confirmed in writing that I should be hired as a management employee. Mr. Noma email says, sounds good to me. I think we're aligned. On April the 5th, Mr. Noma emailed me saying, do you want to execute them? I will countersign them so we can get rolling. The same week, the company's COO welcomed me to the team in writing, and I received a company email address and Slack access. On April the 12th, I was introduced to the entire team as the Chief Investment Officer. I then performed CIO level work for nearly 4 months, work that they accepted without objection, but didn't pay for. I signed both agreements. The signature pages are on the record, and under Arizona authorized citation in my response in section 3, parties form a contract through conduct and words. A counter signature is not the test, and their conduct here is acceptable. At minimum, a reasonable jury would find mutual assent, and on this motion, every inference would run in my favor. On the statute of frauds, there is no minimum term that's terminable. It was fully performed within a year. The work could have been performed within a year. They have no position to invoke the statute of equity. Their attorney drafted the agreements. They invited me to execute them, and they took 4 months of my work. This section, these points are in section 3 of my response, paragraphs 10 and 12. On stock claims, defendant read the words Jonathan Rose or his designees to mean that I somehow lost my rights as Jonathan Rose as a party of the contract. It is my agreement, my signature, and my services. The designee language is serving the routine purpose of allowing me to direct my shares to be issued to my family trust or estate for tax planning purposes. An option regarding where the shares are delivered does not substitute that the trust becomes the contracting party. The contract does not say solely the name of the trust. My name is also there, which completely defeats that argument. Nothing the agreement says or replaces a party to a contract. It takes clear language, not an either or delivery term. The services were mine, the promise ran to me, and the claim for its breach is mine. The subscription statute fails for a separate reason. A subscription is an investor's commitment to buy shares to raise capital for a company. This ran in the opposite direction. Equity was being issued as compensation for services performed. The services were performed, and the Business Corporation Act expressly authorizes it. The provisions are cited in section 4 of my response. And even on their own theory, there is a signed writing. I signed the stock agreement, and it's on the record, and the stock agreement was issued by their attorney. So they paid an external third party to go do something. They don't pay, no one pays an external third party to go do something that they say never actually happened or took place. Finally, even if the court concluded that the trust needed to participate, the remedy under the real party and interest rule is not dismissal. Rule 17b(3) says the court may not dismiss until, after an objection, a reasonable time has been allowed for the party to ratify, join, or be substituted. The Arizona Supreme Court has unanimously held that the cure opportunity does not depend on showing any mistake or difficulty in the original naming. No cure opportunity has been offered here, so even if the defendants were right about the trust, which they're not, dismissal would be improper. I can provide the citation if the court wishes, which is Preston and Kindred Hospitals West, LLC, 226 Arizona 391249. The fraudulent inducement, the defendant says, I elected my remedy by suing on the contract. Rule 8D expressly allows pleading in the alternative, and the election of remedies is made at the remedy stage, not the pleading stage. All 9 elements are supported. Mr. Noma made specific representation about the company's capital commitments and funding pipeline to bring me on board. They were false. I relied on them. I gave 4 months of executive work without pay and gave up other income, so there are actual damages.
And before, thank you. I just wanted to make sure you got to the alter ego issue as well.
Okay.
We're running short on time. Go ahead.
Okay, alter ego. I assert as the theory of liability, not of a separate claim. Two facts alone create a jury question. First, defendant's own production contains an internal cap table listing 14 stakeholders, a document they have denied existed in discovery. Second, they produced a group health policy with an effective date after my separation that never names me, while claiming that coverage obligations were met. A jury may infer unity of control, and that respect of the form here works as an injustice. That's section 6 of my response in paragraphs 50 and 55 of my separate statement. This is a methodology and modality of business operations that Mr. Noma uses, that he takes work for hire from people who are interviewing, and he takes people who he's hired, and then he doesn't countersign the agreement and then goes on and does this to people. I'm not the only person, and discovery would actually produce that if we actually received all of the property discovery that we've requested, which we haven't received to date.
Thank you. And we're at time. We're a little over time. Any closing remarks as to this motion for summary judgment? You'll have a chance to respond to the other as well.
I believe that the May 1st motion rests on its premise that I quote, never disclosed damage computation. My answer to the motion is defendant's own exhibit 3, which is the statement of facts of my initial disclosure statement of July 15th, 2025.
And are you referring to the May 1st? But I was still on the first motion for partial summary judgment. You'll have a separate block of time for the subsequent motion. Anything on the first motion?
No, I am good, Your Honor.
Very well. Mr. Hecht, you'll have about 2.5 minutes in rebuttal to even up the time.
Thank you, Your Honor. So there was obviously a lot there. I'll try to hit what I can here. So in terms of the breach of contract, he talks about conduct. When he was discussing the conduct of the party, he was using a lot of future words such as should, I think. This is all a part of active negotiations between the parties. People hire outside counsel all the time. That doesn't lead to necessarily a finalized product or a hire. That has nothing to do with whether or not he was actually hired as an employee. There is no signed agreement by both parties. His last red lines were a counter offer. He signed it, and we never signed it back. There is, in terms of the alter ego, he mentioned, Mr. Rose mentioned that there was a 14-person cap table. I would argue that actually works in our favor completely. If Mr. Noma was using this corporation as more than a shield and using it for nefarious activities or for fraud or anything like that, there would not be 14 investors in this company or 14-person cap table. And even if it was just Noma, if there was, let's say in this hypothetical universe, Noma was the only investor, that is still not enough under alter ego to prove that he's commingling funds or using it for fraud. So that fails in our eyes.
Thank you, Mr. Hecht. Anything further on this motion?
No, I think that's it, Your Honor.
All right. Thank you to both parties. The court is going to take the first motion under advisement. Now we're pivoting to the second motion for partial summary judgment. Mr. Hecht, I can give about 5 minutes to each side on this one, and as the moving party, you can go first.
Sure, thank you, Your Honor. So I'll start with lost future wages. Again, it goes back to the no executed agreement. But besides that point and that statute, which is ARS 23-1501, which I've cited a few times, Mr. Rose has not proven his damages to a reasonable certainty. Again, we are 3 years into this litigation. Discovery is closed, and all he has for future wages is approximately $10,000 a month until comparable employee is secured. And this is not our burden. It's his burden to prove reasonable certainty. In fact, we've actually tried to, push him to prove this with our. We sent a NUI on March, I believe it was due in May 15th. That's over 2 months ago, Your Honor, and he has still not responded. We've given him plenty of opportunities, plenty of emails. This NUI goes directly towards his past employment, his past employment, and his wages, and all that would help us prove, or at least that would help us show what damages he's claiming, and he hasn't even responded to this. It's 2 months overdue, and so there's zero evidence of post-separation earnings or job search. And when we tried to file subpoenas to get information from third parties that would actually produce information, he moved to quash those. So he can't claim that we haven't proved his failure in mitigation. He hasn't given us a chance to prove our case here, Your Honor. And so that's the big point on lost future wages, as well as there's added force in Arizona to proving future wages. It's not enough 3 years into litigation to say $12,000 a month until comparable employment is obtained. The next point is medical expenses. Again, to date, 3 years after this complaint has been filed, he's produced one medical record for approximately $4,000. He's not getting active ongoing treatment. I believe his treatment ended 6 months or a year after treatment, which would have been 2024. So it's not like these bills are still coming in. He's had 3 years to gather this medical information, and all he can give us is $35,000 plus and ongoing, or I will supplement. Discovery is closed. So this is it's a continuous pattern with this 3 years into litigation. And then the mitigation, we bear the burden of proving that he failed to mitigate, but he has the initial burden of proving damages with a reasonable certainty, which I've stated the reasons why he cannot prove that. He is not cooperating in discovery, and not given our chance to prove our burden. I'll reserve the rest of my time, Your Honor.